Hi, good morning friends. My name is Advocate Manish Chaudhary and today we are going to discuss about the latest news of the Supreme Court. Supreme Court raised quota of judicial officer in High Court judges appointed to 50% plea in Supreme Court. The Supreme Court has sought the response of Union Law Ministry and the Delhi High Court in an application seeking to increase ratio of judicial officer in the appointment of High Court judges to 50%. The notice was passed by a bench of Justice B.R. Gavai and Vikram Nath while hearing an intervention application filed in All India Judges Association case. Currently, the practice followed in High Court is to appoint judicial officer to one-third of the High Court post, with the remaining two-thirds filled up with the member elevated from the bar. During the hearing on February 7, Senior Advocate Rakesh Khanna with Advocates Sachin Jain and Ajay Kumar Agarwal appeared for the applicant. The application moved by the Judicial Service Association of Delhi, relying on Article 217, Subsection 2 of the Constitution of India, said that there are two sources for elevation. As judges of High Court, the first source is the person who has had a judicial officer for at least 10 years, and the second source is a person who has been an advocate for the year at least 10 years. These two sources are independent and separate, the application said. It may further be noted that in the Constitution, no ratio or quota is mentioned about the intake of honorable court judges from the bar or service. Since Article 217, Subsection 2 does not prescribe any proportion for appointment vice versa categories and A and B. The fact that category of judicial officer is placed prior to the category from the bar shows that the framer of the Constitution have treated both equally while practicing more emphasis and responsibility on person who have held judicial officer. In fact, in the scheme of Constitution, the first clause of Article 217, subsection 2 of the Constitution is about the judicial officer from service the applicant appointed out, and only the second clause is about elevating advocate from the bar. The first choice for elevation as a High Court judge, therefore, ought to be from the judicial officer. It argued if the current ratio of one-third of judicial officer quota for elevation to the High Court increased to 1/2 50-50, there would be a significant improvement in the tense of disposal of the case as quality of judgment. The same would further leave no room for any criticisms regarding any lack of experience for holding an esteemed post of High Court judge. As a judge from the district judiciary, when elevated to Honorable High Court, already possesses a minimum judicial experience of at least 10 years as a judge. The plea further argued. Moreover, these appointees to the High Court from the subordinate judiciary had been under the constant supervision and the guidance of respective High Court. Their performance is tested over time, the plea said. Explaining this, the application stated that when candidates of subordinate judiciary are considered for elevation, the requested data is really available. Their understanding and the concept of law and justice. Second, writing skills. Third, behavior with the bar. Fourth, handling of litigants. Fifth, character, which is assessed by the public, the legal fraternity, and the High Court. This apart, a judicial officer with long years of experience on the benches already are recluse without any attachment to with any political ideology. Therefore, for the improvement of institution and for instilling the confidence of citizenry in the judiciary, the quota open to the district judiciary in the High Court can be enhanced to 50%. The application also highlighted the role played by the district judiciary in the society. The district and subordinate court play a prominent role in preserving law and order in the society. It is the public confidence in judicial system that sustain the credibility of judiciary. In generating and boosting the public confidence, the role of district and subordinate judiciary is therefore significant. Further, the application flagged that issue of appointment elevation as a High Court judge cannot be looked upon from narrow perspective of transfer and transferee High Court only. It needs to be seen at the pan-Indian level. The applicant therefore urged the court to issue direction to ensure that the bar service ratios are at least maintained, the appointment of High Court judges and the vacancies from the service quota are filled at the earliest. In the past few years, suitable candidates from bar were not available timely, and many times there is a inordinate delay in filing the vacancies from the bar in various courts. That ultimately prejudice the dispensation of justice, the IA said. The plea also seeks to direct all high courts to fill the vacancies from judicial service quota expediently. Another development which happened during the hearing was that the Supreme Court took serious exception to certain states not coping with earlier direction regarding enhancement of pension of retired judicial officer. The matter will be next heard on February 28. Thanks for listening, friends.